through the window when the matter about the man never owned the land. Gone through the window. Okay? That's out the window. The claim. So this is from the claimant. This is the Minister of Housing representing the occupiers. On May 18th, 2012, the claimant filed a fixed date claim form seeking declarations and order. A declaration that the Minister of Housing is entitled pursuant to Section 6 of the Land Acquisition Act 1947 and Section 25 of the Housing Act to compulsorily acquire part of all the land known as Orange Grove, south of Cooper's Pend, and Burnwood Beach, containing 9 acres, be the same more or less, and being part of lands registered at volume 1008, folio 636, at the registered book of titles, as more particularly described in the technical description dated May 1st, 2012, prepared by Mr. Amos, land surveyor, employed to the Housing Agency of Jamaica Limited. A declaration that pursuant to Section 15 of the Land Acquisition Act, the Minister of Housing may direct the Commission of the Lands to take possession of all the lands known as Orange Grove, south of Cooper's Pen, and Burnwood Beach, containing 9 acres, be the same more or less being part of lands registered at volume 1008, folio 636 of registered book of titles, as more particularly described in the technical description dated the 1st of May 2012, prepared by Mark Amos, land surveyor employed at the Housing Agency of Jamaica. By Section 16 of Land Acquisition Act, that the lands known as Orange Grove, south of Cooper's Pen, and Burnwood Beach, containing 9 acres, be the same more or less and being part of land registered at volume 1008, folio 636 of the registered book of titles, as more particularly described in the technical description dated May 1st, 2012, prepared by Mr. Amos, land surveyor employed to the Housing Agency of Jamaica Limited, now vest with the Commissioner of Lands. An order that respondent New Falmouth Resorts Limited shall be compensated for the said lands according to the provision of Section 14 of the Land Acquisition Act. So right there, so just to give you a synopsis of where we are going here, so the Minister of Housing claim that they have the laws to force the man to give up him land. That is what they say. That is it in a nutshell. Zane? That is it in a nutshell. So they might use the same thing we are here. The ex-convict talk about or him go use. Them use it already. Them use it already. The sitting we are here, chapel line, I say him go use. Them use it already. Zane? See that? Their claim, a declaration that pursuant to Section 15 of the Land Acquisition Act. Always in the matter about them and look at stooges them for them go do them own research. Them just trust these people who call themselves lawyers and all them things there. And we have AI now, we have Google now. If you don't know a word, they can put it in and make it come up. If you say a foreign word, they can get the right pronunciation. All of them things there. So nobody no brighter than nobody now. If you can't read it, make it read it for you. So you have no reason to be ignorant and make nobody a turn in a idiot in a 2026. So when these people come with their titles upon them name, and why if you just accept what they say and some little idiot on some platform, through them company platform, frightened and start lick them chops. You can go do your own research. We're living in a digital era, a technological era where everything is at your fingertip. So in a nutshell, this I say basically say, yeah, them want the man sell the land. For be me where them want pay for it. All right, good. By section 16 of Land Acquisition Act, the lands known as Orange Grove south of Cooper's Pen and Burnwood Beach, containing 9 acres, be the same more or less. I think I read that already. All right. An order that respondent New Falmouth Resort Limited shall be compensated for the said lands according to the provision of section 14 of the Land Acquisition Act. So that's the matter about. So them are going to use. An order that the respondent New Falmouth Resort Limited be restrained. Listen this. You hear them saying put caveat on the man land? Listen this. Listen to this where the government did. This is what the government did. Yeah? In 2012. An order that the respondent New Falmouth Resort Limited be restrained from transferring, parting with, and or disposing of its in the lands known as Orange Grove, south of Cooper's Pen and Burnwood Beach, containing 9 acres, be the same more or less, and being part of lands registered volume 1008 folio 636 of the registered book of titles, as more particularly described in the technical description dated May 1st, 2012, prepared by Mr. Amos, land surveyor, employed by the Housing Agency of Jamaica Limited, without the written consent of the Minister of Housing, or an order of this court. An order that respondent New Falmouth Resort Limited be restrained from evicting water break. Class in session. All the people who live a foreign of your land in Jamaica, pay attention. All the people when their mother and their father work hard, when them dunce mother and them dunce father who couldn't read and write, but them have ambition, and them pick the coffee and pick the chocolate, and they busy and carry upon their head and buy land when land cheap. The government, after people take away your land, I go tell you, say, an order that the respondent New Falmouth Resort Limited be restrained from evicting, harassing, intimidating, molesting, and or disturbing in any way of the current occupants currently on the land known as Orange Grove, south of Cooper's Pen and the Burnwood Beach, containing 9 acres, be the same more or less, being a part of the land registered volume 1008 folio 636 of the registered book of titles, as more particularly described in the technical description dated May 1st, 2012, prepared by Mr. Amos, land surveyor, employed to the Housing Agency of Jamaica Limited, without a written consent of the Minister of Housing and or orders of this honorable court. Imagine that. And that society they want to harassing. Can't go harass nobody by my land. Papa Jesus, if you're not busy, come here. Papa Jesus, if you're not busy, come here. Eh? Your mother we couldn't read, and your father we couldn't read, left piece of land give you. And you live a foreign, because you go a foreign, you migrated. But you think you still have land in Jamaica. When you come back, people they pay your land and the government come tell you about you can't go harass the people about it. Jesus, come down. Come, Jesus, come. Somebody type in a comment and tell Samuel who own the land, because I can't go back over all of this, because I read so the land registered, and I read the title number, everything. So one time. I'm doing it one time. It is established based on the court record that the land was owned or is owned, yeah, by the New Trelawney Resort Limited. Yeah? So maybe you just join the class. All right. So, let's continue. Section 7. Excuse me. An order that the respondent, New Falmouth Resort Limited, be restrained Listen. An order that the respondent New Falmouth Resort Limited be restrained from demolition, removing, or altering any of the structures currently on the land known as Orange Grove, south of Cooper's Pen and Burnwood Beach, containing 9 acres, be the same as more or less are being part of the land registered at volume 1008 folio 6. I'm not read it again, right? Because I'm tired of reading that part. Let me read it again, because I'm going to say, me go skip it out. So, an order that the respondent, New Falmouth Resort Limited, be restrained from demolition, removing, or altering any of the structures currently on the land known as Orange Grove, south of Cooper's Pen and Burnwood Beach, containing 9 acres, be the same more or less are being part of lands registered at volume 1008 folio 636 of the registered book of titles, are more particularly described in the technical description dated, I'm going to dream this tonight, May 1st, 2012, prepared by Mr. Amos, land surveyor, employed to the Housing Agency, Jamaica Limited, without the written consent of the Ministry of Housing or an order of the court. The affidavit of Simone Morris Ratchery in support of the fixed date claimed form states at paragraph 12 to 16. So again, who is Simone Ratchery? Who is Simone Ratchery? So Mrs. Jacqueline Samuels Brown, QC, instructed by Hollis and Company for the claimant. Mrs. Juliet Mayor Rose, instructed by I think this is Riam I'm not sure the pronunciation. I'm not sure the pronunciation. The fixed date claim form states. So this is a claimant. Yeah? This is a claimant. Over the years, the land has been occupied by over 100 families as informal settlers. These families have contended that they have occupied the lands for over 15 years, and several even averred that for generations they had established their homes, raised the families, and built a vibrant community. Many of them work in fishing, craft vending, and the hospitality industry in the nearby hotels. Nearly all the occupants have established permanent concrete structures on the land and have the usual amenities of water and electricity. Over the years, it appears efforts were made to properly organize the residents through a provident society called Cooper's Pen Provident Society in order to formally acquire the lands. Nothing came of that effort. The registered proprietor has contended that through its principal, James Chisholm, the landowner, he also made representations and sought to have the residents participate in a scheme to purchase a part of the lands. That in 2007, the registered proprietor of the lands, New Falmouth Resort Limited, the respondent hearing before an action to recover possession of the land from these occupants. Mr. Chisholm is the man who owned the land who attack, the defendant. In his affidavit dated the 4th of June 2012, in opposition to the application for injunctive relief being sought on behalf of the occupants, complaints at paragraph 13, that for more than a decade, I have been appealing to all government agencies. This is Mr. Chisholm now. That for Mr. Dead Chisholm, Ganu, is in the grave. But this is his speaking. This is him speaking. that for more than a decade, I have been appealing to all government agencies to assist the squatters. That Mr. Chisholm, you know. I have been appealing over a decade to all government agencies to assist the people them, including the HAJ since 2002, to no avail. Attach an exhibit here to marked as JHC3 for identification is a copy of some of my various correspondences over the years to anyone or any government entity I believe could help, including Prime Minister of Jamaica. The most honorable Portia Simpson Miller. Mr. Chisholm went all the way to the Prime Minister for assist the squatters. This composite exhibit not only demonstrates the tremendous efforts made by New Falmouth Resort Limited over the years to stop the squatting, but also demonstrate the appeals made to HAJ and the Minister of Housing to assist the squatters. No one has helped. That to date, 2012, there has been no attempts by the HAJ to assist the squatters in any way that is beneficial to all parties concerned. It appears that they are active in their attempts to continue to pervert the course of justice, as squatters are now telling everyone that their member of parliament is going to take the land from New Falmouth Resorts and let them stay on it. The government was banking on the Housing Act for tick. Calm down, youth. Calm down. Water. Water. Water, Jesus. Water. Continue to tap the screen, man. Tap the screen, tap the screen. Me nah sing no more until no return. I need my voice to go sing Friday, you know. We have to tap up the screen, people, and put F1 so them know report the live. Do him some F1 and some tap up. Remember, say my voice me I use, you know. I mean, I beg you no nothing. Me just do this so people when have their land and people will live a foreign don't make PMP get back in a power. That's why me I do this. Me no want to let back PMP in a power. The people in the diaspora where have your land in Jamaica, call the people in Jamaica and tell them say don't vote for PMP. Them wicked. All them want a votes. That's why them plan for sabotage Nara. Call the family when you go come pay the land tax all long and tell them go pay the land tax. Because God forbid them people are going to take this country and then gone with their land. That is the reason why the man were in charge, the shadow minister for housing. That's why I come the other day and tell the government to remove all the requirements so people can get land. To remove all the safeguards so people can thief land. Yo, water. Water. All right, we over, yeah man, see them man, we over 30. Let's go again. Can we make it get up to 100? Right? Right and whistle. All right. So let's read section 14 again, people. If you're just joining, this is the case file of 2012. Legitimate case file. Section 14. This is from the defendants. The defendant representatives and Mr. Chisholm account. To date, There has been no attempts by the HAJ to assist the squatters in any way that is beneficial to all the parties concerned. It appears that they are active in their attempts to continue to pervert the course of justice, as squatters are now telling everyone that their member of parliament, is going to take the land from New Falmouth Resort and let them stay on it. Now, why this makes sense? Now we understand why nobody never try pay no tax. Now we understand why nobody never try do no adverse possession. Now realize why the people in the thing say everything good and continue to build. Now we realize what? Now we realize. Now realize. Now realize that in 2012 it was all concrete structures there. Nobody planned to move. Nobody had planned to leave. The people didn't plan to leave. The PMP told them that they would, according to the information, that they will get the land. That's why PMP couldn't lose down there. Kupa Jesus. That's why PMP that run they see that's so long. Macintosh J orders. Yeah? This is Macintosh J orders. Yeah? And this is Judge Macintosh. That in 2007, New Falmouth Resort brought an action to recover possession of the land from persons in unlawful occupation. On the 6th of April 2010, Macintosh J granted an injunction to New Falmouth Limited restraining the, listen people, listen carefully, listen this, that in 2007, New Falmouth Resort brought an action to recover possession of the land from persons in unlawful occupation. On August 6th of April, on the 6th of April, 2010, Macintosh J granted an injunction to New Falmouth Limited restraining the occupants, their servants or agents from doing any further construction whatsoever on the New Falmouth Limited lands at Orange Grove, France, all being lands registered at lands limit. Let me read it again. Registered at volume 1008, folio 636, and volume 1389, folio 427, and volume 1109, folio 442 of the registered book of titles. 20. That in 2007, New Falmouth Resort brought an action to recover possession of land from persons in unlawful occupation. And on the 6th of April 2010, the judge granted them the injunction, restraining the occupants from what? Building further concrete infrastructure. All right. Each defendant was ordered to pay $50,000. Each defendant was ordered to pay $50,000, times that by 100. Or 99, them say. In damages for what? Trespass. The judge ordered the people them were upon the man land, where the government had promised them, according to the report, to pay the man $50,000 in damages for trespassing on the man land, wrongful occupation of the claimant's land, and to demolish and remove their illegal structures from the claimant's land. Leg off Andrew on the shirt. Leg off my Prime Minister shirt. And go cost, PMP. Past and present party. Each defendant was ordered to pay $50,000 in damages for trespassing, wrongful occupation of the claimant's land and to demolish and remove their illegal structure from the claimant's land. So all who are on the internet I say them never seen nothing about no demolish, and the idiot liar, idiot drug smuggling liar man with the on the internet I tell people if you go chop a line and if you go broke a bed foot go claim so they may lose things. It is here. And one of the rulings it is here. Is it? Because you have some duns PMP vloggers. Well, when they present nothing, they cut off piece. Each defendant was ordered to pay 50,000 in damages for trespass, wrongful occupation of the claimant's land, and to demolish and remove their illegal structures from the claimant's land. It is unchallenged that the occupants have not paid the sum or demolished or removed the structures as ordered by the court. Good. Good. Nobody can bad me up. Nobody can tell me if you accept nothing, I don't accept. Me have empathy, but me are no dunce. I not be no dunce. I not support no lawless society. I not support no politician. I not support no party where I promise people things and when time to fulfill it, then left the people them hanging. And people fi stop take promise fi vote. Stop take handout and promise fi vote. The PMP should never see back governance in this country. They are wicked. But you Marky G run guard, Master Mark, run guard on people them place. No shame. No shame. No shame. After you demonstrated against the Mona Commons people them. You run guard now down a next squatters place now. You guard now with people them. Lord Jesus. Let's continue. That an application was made before the court on March 8, 2012 for injunctive relief as well as stay of execution of judgment in claim HCV 01702/2007. And, on the 20th of April 2012, McIntosh J heard the application and adjourned until May 4th, 2012, requesting that either the Honorable Minister or the sworn affiant of the Housing Authority should appear. So let me read that again. That an application was made before the court on March 8, 2012 for injunctive relief as well as stay of execution on the judgment in claim HCV 01702/2007. On the 20th of April 2012, McIntosh J heard the application and adjourned until May 4, 2012, requesting that either the Honorable Minister or the sworn affiant of the Housing Authority should appear. The learned judge recognized the presence of agents of the Ministry of Housing in court, and copies of his orders were handed to those persons. Neither the minister nor Mr. Shukir appeared. Neither the minister or Mr. Shukir appeared. McIntosh J refused. The judge refused the stay of execution and order cost be paid to the claimant. Leave to appeal was granted. No appeal was pursued. PMPism. The learned judge recognized the presence of agents of the Ministry of Housing in court, and copies of his orders were handed to those persons. Neither the minister nor Mr. Shokir appeared. The judge, McIntosh J., refused the stay of execution. What does it mean to refuse the stay of execution? I am the one. I am the one. I am the one. Moving us off of the land. What does that mean, Mr. I am the one? It no mean say the PMP will never show up at court the day. The minister never bother show up. Jesus and them want kill Andrew Holness. Me see people down there bow. Of course, the people them we are look for Andrew help them know a course Andrew. And bare-faced market British. Gone down there, him and the chop the line MP. Gone down there, gone further. Take the people them when not have no roof over their head tonight for fools. I want to company internet. I want someone who have cuss. I tell people about them mama. I tell people about some no squatters. I want to be squatters now in a country. And all of these nonsense because PMP from Michael Manley days make on believe say where people have a phone. Yeah? From Michael Manley days when I tell the people them catch the next flight out, 5 flight I leave. We don't have a mentality. We don't have mama we still a look up in the ear when no roof, no depend house top. We still a look up where a stalwart in a PMP from she a picnic, from she a teenager, from she in her 20s like some of them PMP vloggers here without teeth. We don't believe say when we work hard, our parents them work hard, and we come work hard, and we have put on resources so we picnic them a phone. So we hug up market British today and chop the line MP. And now cost the PMP we promising us we're not going to get the land. Margie Stewart. Margie, just go to Minister of Housing versus New Falmouth Resort. Yeah. A good way for you, Margie, to find document that you may not find just when you put it on Google. Go to ChatGPT and you type in what you're looking for, and it will dig it. It search the whole internet and pull up where people not even find. Yeah, look, use up the new technology where we have at our fingertips. Go into ChatGPT and put in what you're looking for, and it will pull up everything for you. Everything. All from Michael Manley time. So, leave to appeal was granted, no appeal was pursued. And this is 2012. All right, let's continue. Claimant submission. The claimant relied, this is very important, people, let us work. The claimant relied on the learning in American Cinnamid Company versus Hethicon or Hethicon Office, 1975. The PMP them draft your case file in America. The PMP draft your case file in America to use as their argument, to substantiate their argument. A case file in America. American Cinnamid versus Hethicon Office, 1975. 1 all 504 and National Commercial Bank Jamaica Limited versus Olint Corporation Limited. Olint? What is Olint again? Limited. Privy Council Appeal number 61 of 2008. Just what is Olint again, people? What is Olint again? Me know what I named it. What is Olint? Olint was this. I am the one. Olint at the same. I see him come. Holy Jesus. And them say Andrew go use when the cash plus money. They say Andrew put money in a cash plus the PMP I use all lint. All lint. PMP I use all lint. All lint. Pansy whole lint. As in case file. Somebody put. How can I hat that to put for me? Give me another hat. Give me one more day hat then. Come me have to read this again. Me have to read this again. Give me one more day hat then. Me what kind of hat that? Eh? What kind of hat is that? This have to read again. Bam! No move it out. It gone already, man. Me say, listen people. The claimant, which is the PMP, yeah? The claimant lied. No wonder they want to say we got CCJ for the final court. Yeah, they can pervert the course of justice. Eh? No wonder they want to move overlook a bridge. Because PMP claimant relied on the learning in American Synamid Company versus Ethicon Office 1975 1 or 504 and National Commercial Bank Limited versus Olint Corporation Limited, Privy Council Appeal number 61 of 2008, to support the propositions that the real purpose of an interlocutory injunction is primarily to enable the court to do justice after the determination of the merits at the trial. In doing so, the court will be concerned to protect the claimants against injury by violation of his rights, for which he could be compensated in damages if the action were resolved in his favor at the trial. It was further submitted that the court must balance this against the need to protect the defendants against injury at a trial as a result of his having been prevented from exercising his own legal rights, for which he could not be adequately compensated if the case were to be resolved in his favor. At the interim stage, the court is not concerned to resolve conflicts of evidence if there is any such conflict, but rather to assess whether the plaintiff has any real prospect in succeeding in his claim for the permanent injunction at the trial. Counsel submitted that it should be appropriate to take into account, in tipping the balance, the relative strengths of each party's case as revealed the affidavit evidence adduced in relation to the application of the injunction. Mrs. Samuels Brown outlined the statutory context in which the claim is launched by the Honorable Minister, the Minister of Housing. She pointed out that Section 18 of the Jamaica Constitution, listen to this, enables and empowers the government to compulsorily acquire private property so long as it is under the provision of a law that, 1, provide for the citizen to be compensated, and subsection B, give any person claiming an interest in or right over the property access to the court. So the claimant, the people who are trying to take away man land, I said the law give the government the power to compulsorily acquire private property. And now you understand why you see the PMP them are run with this, and I say, yeah, government can take any land them want to take and give to people. Not so. That is PMPism. That is PMP socialism. That is PMP Michael Manleyism. That is PMP your own and my own ism. That is the ism where the PMP them, that's why people may pack up them business and run away. That's why the people can catch a flight them out, because Michael Manley and this PMP ism where them formulated are introduced to the people. And to this day them believe say, what I feel them. So government can come take your hard-earned money where you buy a piece of land and take it and give people. And that the PMP can go court. "13. That Section 4 of the Housing Act allows the minister to declare a particular area to be housing area if he is satisfied that the conditions in Section 6 of the Housing Act exist." Now, before we go no further with this, let us look at Section 6 of the Housing Act. Let us go there. Let us go there. Let us go to Section 6 of the Housing Act. Wait, the Housing Act. All right. Maybe I go through it earlier and I make some notes. So make we find Section 6 of the Housing Act. Section 6 of... All right. So let us go over this quickly. So they're relying on Section 4, right? So let's go over this. "The minister, after considering the housing conditions in any area and the needs of that area," pay very good attention, "and the needs of that area with respect to the provision of further housing accommodation, may cause an area to be defined on a plan and may by order declare the area so defined to be a housing area." So this is what them rely upon you say, you know, that the minister can define the area and a housing area. "Whenever the minister declares any area to be a housing area, he shall," which must, when you see shall in a law or anything to deal with the courts, shall mean you have to. Mean is not no if, buts, or maybe. Why for the buts? Right? "He shall." Right? Right, Impact? "He shall." Right? "Within the period prescribed," which the period is 9 months. Yeah, you can look up that. I can show you later on if you want me to. Yeah? "Prescribed in subsection 2 of Section 8, cause to be prepared proposals for the provisions to further housing accommodation in that area." Yeah? "Hereinafter in this act referred to as a housing scheme." So first him have to what? Define it a housing area before him can get to what? A housing scheme. Yeah? "If the minister," listen carefully, "after considering the housing conditions in the area is satisfied," listen, "that in general the houses in such area are by reason of disrepair." That means say, as some old shack him have to come see. Or are some also they by the gully bank when they have spin propeller. Yeah, sanitary defects. Yeah, unfit for human habitation. Yeah, or by reason of their bad arrangements or the narrowness or bad arrangement of the streets, or by any reason of crowding in the area, dangerous or injurious to the health of the inhabitants of the area, and that most satisfactory method of dealing with the conditions in the area is the demolition of all the buildings in that area, and that the clearance of the area can be secured in one of the other of the following ways, or party in blah blah blah. So what them can go quote now? Then carry this go quote, Section 4. But key point, pay attention class. If the minister, after considering the housing conditions in any area, is satisfied that in general the house in such area are reason of disrepair, means you have some old pop down house can't repair, sanitary defect, yeah, people are living in a pig pen, yeah, feces or something, yeah, no sewage, blah blah blah, unfit for human habitation. All right, so let's go to Section 6 quickly. Right, where them bring up again. If the minister, after considering the housing conditions in any area, is satisfied that in general the houses in that area are, by reason of disrepair or sanitary defects, unfit of human habitation, or by the reason of their bad arrangement or narrowness of bad arrangement of the streets, or by reason of overcrowding, same thing when we read a while ago, right? With Section 6, right? Or injurious or injurious reconstruction or repair as the circumstances may require of such dwelling houses or buildings are unfit for human habitation or blah 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 blah. So then carry this guy quote. But me I go show you the problem when them running up. Let me show you all the problem that they ran into. Yeah? So back at this. So we understand that. Section 4, read it to you a while ago, and section 6, right? Because I know so we don't really, you know, I go leave in a wonder. We are going to full breakdown. If the minister considered that in general the houses in that area are by reason of disrepair or sanitary defects are unfit for human habitation, or the area is badly laid out or arranged, or there is overcrowding such as to be dangerous to the health of the inhabitants, and if the minister further considered that such conditions can be effectively remedied, he may by order declare the area to be an improvement area. Yeah? It is further submitted that pursuant to section 25(1) of the Housing Act, any land, yeah? This is how we then come back pan again, but the reason why I keep you on the screen, I want to show you section 25. Any land, yeah, listen this. Listen and go quote with. It was further submitted that pursuant to section 25 subsection 1 of the Housing Act, any land proposed to be acquired for the purposes of an improvement scheme, etc., may be acquired in accordance with the provisions of the Land Acquisition Act. And in relation to the acquisition, the purposes aforesaid shall be deemed to be public purposes. So here now is the defendant's submission. The respondent's submission was for the fixed date claim form to be struck out pursuant to Rule 26.3 subsection 1a(b) and Rule 26.3 subsection 2. It was argued that the claimants were stopped. Right? This is e-stop. This is the name they use in the law. Yeah? So this is the claimants were stopped from pursuing the issues in these proceedings, which is the same claim and the same relief that were advanced against the defendants in claim number 20078CV01702 filed on March 8, 2012. Now, why is this important, class? Why is this important? It is important because anybody we are going to take up this and want to carry a quote again, like chop the line. The same provisions are going to come forward. It's going to be stated that this was already filed. This is a dead matter. The PMP never even gonna show up a court because they go court for something with them not. Anyway, further, the claimants are raising the suit issues directly and substantial that have been raised in former suit under a notice of application for injunctive relief and stay of execution filed on March 18, 2012. The same issue have been raised, heard and finally decided on March 4, 2012. Mrs. Rose, counsel for the defendant, also urged that the second claim breached the principle of res judicata. I be a boof, the judge a boof them. The court boof them. See it there. The court was referred to Arnold versus National Westminster Bank 1990, 1 RER 529, and Tuani Limited versus Indru Kemlani 211 JMCA, blah, blah, blah. The claimant's application on the 6th of March 2012 in claim 20078CV11702 applied for injunctive relief and stay of execution. The claims in that matter relied on the affidavit of Joseph Amin Shokir, the managing director of the Housing Agency of Jamaica, acting as the duly authorized agent of the Honorable Minister of Housing, paragraph 5 of the notice of the application states that the Honorable Minister of Housing has declared the lands comprised in Certificate of Titles registered volume 1008 folio 636 and volume 1389 folio 427 the lands to be a housing area in accordance with Section 6 of the Housing Act. Having so done, the minister is at liberty to acquire the land in accordance with the provisions of the Housing Act of Land Acquisition Act, see Section 25.1. Now let's go to Section 25.1. So here's 25 land. 25.1. Any land, including land with buildings thereon, which is under or by virtue of the provisions of this act, proposed to be acquired for the purposes of any housing scheme, slum clearance scheme, improvement scheme, or emergency housing scheme approved under this act, or for purposes incidental to or connected with any such scheme, may, subject to the provisions of Section 2, be acquired in accordance with the provisions of the Land Acquisition Act. And in relation to such acquisition, the purposes aforesaid shall be deemed to be public purposes. For the purpose of the acquisition of any land as aforesaid, the Land Acquisition Act shall have effect subject to the modification that for the reference in the subsection 1 of section 16 of any act, to a vesting of the landing commissioner of lands, there shall be substitute a reference to the vesting of the land in the minister wherein within the meaning of this act. Listen this now. Can I left out this? Nothing, all the liar them will represent and the minister them will represent the PMP. All them come like the PMP them will chop off piece when they read. 26. Nothing in this act shall authorize the compulsory acquisition of any land which is the property of a statutory undertakers having been acquired by them for the purposes of their undertaking. 27. The minister may pay out, may pay out the housing fund to any person displaced from any dwelling house or other buildings in a slum clearance. So what does this mean? That means if them go somewhere and see people that live in a slum and then move them like where they might tabo down a paroti, so people can't some place is inhabitable. Then they move them, they have to pay them. Area or any improvement area as the cause may be, which has been acquired by the virtue of the provision of this act, has been unfit for human habitation and not capable of reasonable expensive of being rendered so fit, so reasonable allowance as he thinks fit towards the expenses of such person in removing and to any person carrying on any trade or business in that such dwelling, house or other building, he may also pay such reasonable allowance as he thinks fit. What is wrong with these people? People top of the live. They might report. They're reporting. Top of the live. Run it red. Run the live red. Then I want the truth come out. No. So, their claim is, the claimant occupation March 6, 2020, claimant 2007 applied for injunctive relief of stay of execution. The claimants in that matter relied on the affidavit of Joseph Shokir, the managing director of the housing agency in Jamaica, acting as a duly authorized agent of the Honorable Minister of Housing, paragraph 5 of the notice of application. 5 of the notice of application. Folio 2427 lands to be a housing area in accordance with Section 6 of the Housing Act. Having so done, the minister at liberty to acquire the land in accordance with the provisions of the Housing Act or Land Acquisition Acts. See Section 25.1. In paragraph 6 dated 7th of June 2012, in support of the application, it is stated that the Minister of Housing and Housing Agency of Jamaica Limited had an interest in this matter as it touches and concerns the occupation of land in Western Jamaica, of which a significant community of persons have been in possession and have established their homes. The basis of the claim is the same that the Minister of Housing had issued on February 29, 2012, orders declaring the respondents' land an improved area. Listen good. Listen what the minister do. The minister declared the land an improved area. Justice Donald McIntosh considered that mistrial order and ruled on May 4, 2012. The claimant disregarded the order. Listen this, people. Listen this. Listen this, people. Get your seatbelt. Get your seatbelt. Get your belt. Get your seatbelt. The basis of the claims is the same that the Minister of Housing had issued on February 29, 2012. Orders declaring the respondents' land an improved area. Now, if you want to declare the land an improved area, it has to reach certain threshold. But when they went there, I'll be a concrete pretty house with water and electricity, proper buildings. So it says here, the basis of the claim is that the Minister of Housing had issued on February 29, 2012, orders declaring the respondents' land an improved area. Justice Donald McIntosh considered that ministerial, order, maybe I said something wrong like that ministerial order and ruled on May 4, 2012. Listen what them do. The claimant disregarded the order of the judge. See it here. The claimant disregarded the order. Look at these people. Listen, Tam jump, but Tam no fool. The claimant, which is the government, disregarded the order and proceeded on May 15, 2013 to gazette the ministerial order in relation to the same lands under volume 1008 folio 636. Them went against the court order and go gazette. Said the land is a housing area. After the judge denied them such, and then a show up a court. That the affidavit of Simone Morris Rattray dated May 18, 2012 in support of the second claim admits that the second attempt in the adjudication was premised on this declaration of the Ministry of Housing, and for the simple reason that the claimant could not comply with Justice Donald McIntosh orders. What? Couldn't hear ya. The live are freeze. I report them, I report it. Go try to get through this quick and fast. You know, when dunce people I make up things, when I look on them, you know, I dunce them, the man. We are really there, so. We can't restart it, man. We're going to mash up the whole thing. Is everybody getting a freeze? I report them, I report it, you know. All right, so everybody, let's go. Let's see if we can get through it. That the people, look what them do now. The affidavit of Simone Morris Rattray, dated the 18th of May 2012, in support of the second claim, admits that the second attempt in adjudication was premised on this declaration of the Ministry of Housing, and for the simple reason that the claimant could not comply with Justice Donald McIntosh orders because it would result in serious social and economic turmoil. What? What the? What the? What? Papa Jesus, come here. The government defied, went against the judge's order, gazetted, when them believe said them were, yeah, name the place housing area, yeah, went against the judge's order. I know what was their claim to do it. You know what was their excuse? The people them are going to get wicked social turmoil because of bad people them. So we are going to have economic and social turmoil. Any Papa Jesus, you have your land and got court and the government I come tell you, the government we have police and soldier come tell you say, them went against the judge's order because them fear social turmoil. Them fear social conflict. And man I come talk about chop the line to them, the people who all PMP I say, they may be social turmoil. No, them not now, they say, because it would. They don't say maybe. This is what PMP say. The PMP say they did not comply with Justice Donald McIntosh orders because it would, it will, it would, it ago result in serious. They straighten it. They say it's serious. Eh? Serious social conflict. Serious social turmoil. Are y'all thinking, Megs, leave me alone, man. Are y'all thinking what I am thinking? Are y'all, wrap up, select our card. Are y'all thinking what I am thinking? You think that's why they get police up there? That's why they go 3 o'clock. People, I'm sorry for when I go through, but the PMP say there will be social conflict, social turmoil. The PMP never said nay, no. The PMP say a social problem. So maybe that's why the PMP setting up. And the people them we are going to claim their land afraid. I said them are come 3 o'clock when they're not sleep. The PMP painted a picture of when like when I go cause problem and when I go war. Jesus. And I then come visit you now. The photo apps. Mighty God. Jesus. And so PMP did tell. The PMP say them no follow the judge's order. And promise you no say them a go in the land. After the judge say, you can appeal and them don't appeal. Then they come now, mostly in 2015, 2016, say them a file lawsuit. And them claim say, this thing here, judge, court, justice system, we have to give them the land, you know. Because if we don't give them the land, a war. Mighty God. What a Jamaica to live in. Me gone. Me gone. What a Jamaica to live in. Where government attack about there will be social and economic turmoil. The affidavit says at paragraph 16, since the court handed down its judgment, the occupant sought to have it stayed. This was premised on a declaration that was granted by the Honorable Minister of Housing on the powers conferred under the Housing Act. Higher than the court. No, me think that's something I want me cause tonight. Me think that want me cause bad one. Listen me, people. Gentle people, law-abiding citizen. Listen me. That's something I want me cause bad tonight, you know. And me, I gonna be a Christian man tonight. Me not make you draw me out, you know. PMP, me not make you draw me out. Since the court handed down its judgment, the occupant sought to have it stayed. This was contingent, premised on a declaration that was granted by the Honorable Minister of Housing on the powers conferred under the Housing Act. Oh, you go put Housing Act when the judge don't tell us, say, you don't have no stay. The people, if you come out 5 people in the land. Oh, you gone now at about say you have powers conferred under the Housing Act. The application for the stay was triggered by an attempt by the Jamaica Public Service Company Limited, who sought to discontinue the provision of electricity services to the occupants and to terminate their customer contracts. The respondent argues that it is unfair, unduly burdensome, and outrageous to compel the respondent to forfeit its land to circumvent a riot by illegal occupants who want to remain in occupation contrary to a court order. Now, what is chapter line out there about? Where chapter line out there say? When chapter line out there about say Andrew have to build back everybody else. And I'm gonna wear a green shirt when everybody get back their house. So Andrew are going to defy the court's order. Andrew and the Jamaica Labour Party now going to take this into. Listen to me. God bless the people them soul. Take care of the little children them. Please, anybody can help get them back some books and some laptop, and trust me, it's a bad. Listen to me. People, never ever trust the PNP. You don't need to learn. The next election, not even Mark Golding to win a seat. Do not let the PMP run out here and trick on with them surrogates. You go against the court's orders from 2012. No, we're not 2027. You go against the court order because the people are going to riot. So how kind of society this? You take my land and become me afraid, say you're going to riot, me just get up to... Yo, I want to stop here, man. I want to stop that something here, man. And then we afraid to talk about it. And we just kiba. And everybody feel just silent and just cuss the police, them and cuss Andrew and just cuss the government. We're not idiot, man. And then now we say we're heartless and we're cool and we not have empathy. Want to the PMP government. We could have relocate the people them from long time and take care of the people them before the people them continue to build up infrastructure upon the land. Before Pitney start born upon the land. Before Granny get old upon the land. Eh? The man in 2012, the man showed the document and show the all of the information and the evidence. He might fight for the people and come off him land from 10 years before 2012. And the man shows all Portia Simpson he meet with. And when I come now at about say, you want to know who give authority? When I come now like you want to about say, and boy I come to about for light fire, Black Road and light fire. Hey boy, I want to hey boy. You think you can come mash up Jamaica? You think you can come instigate a riot in our country? Eh? You think you can come instigate a riot in our country? You have to hide and chat. The military did a deal, do no. PMP trick the people, them, that's why them did that win the seat all along. And Tova come now say the people, she don't have no evidence of the people them getting eviction notice. Tova go do your research. But me no say I the MP and you know what, nobody run out of the place. No, twep. The respondents argues that it is unfair, unduly burdensome, and outrageous to compel the respondents to forfeit its land to circumvent a riot by illegal occupants who want to remain in occupation contrary to a court order. That a failure to comply with the court order issued on May 4th, 2012 in the first proceedings and bringing the same issue back to court with a different claim number is an abuse of the process of the court. So tell Chop the Line say no matter how him try package this and carry back a court, had the same outcome. Them try that already, Chop the Line. To accommodate any such action would not give effective to the overriding objective of the court as set out in section 1.1 of the CPR. It was submitted that a statutory condition was not satisfied for the reason that public purposes generally defined means the benefit of the populace, whereas this is intended for a specific group of 99 squatters. Further, the minister must be satisfied that the house in that area is... No. Listen, no. Don't scan. Don't move so fast. Listen this. To accommodate any such action will not give effect to the overriding objective of the court as set out in section 1.1 of the CPR. It is submitted that the statutory condition was not satisfied for the reason that public purpose generally defined means the benefit of the populace, whereas this is intended for a specific group of 99 squatters. Further, the minister must be satisfied that houses in that area is unfit for human habitation, or by reason of their bad arrangement of the streets, or by reason of overcrowding. The respondents deny that the majority of the houses meet those criteria. Further, the minister has not followed the due procedures for valuation. So the lie want to come and tell about the people and value the house and it was 15 million is nonsense. But value the land, we no go with that. In order for them to name the place. So they could take with the people something. Them have to prove say a beer all house over there tumble on the people them. It can't be for public purposes. It can't be for public purpose. Because when they go over there, be a pretty house, the people and go see over there in a good condition. Mrs. Samuels Brown QC. Mrs. Samuels Brown QC in reply stated that the fact that the claimant had joined in an application initiated by others to do something, which by injunction of the parties were forbidden to do, did not bar him from obtaining an injunction in the case then being litigated. That to the furthest, one can say that the affidavit of Mr. Joseph Amin Shokir showed where the government sympathy lay and revealed its thinking at that time. But the principles of res judicata and abuse of process as a term of art are not relevant. So here goes the analysis. Is there material before this court on which this court could hold as the claimants, applicants are contending that there are serious issues to be tried? Having the applicants a real prospect of being granted a permanent injunction for which they have prayed in their claim. The Privy Council in any Young versus Luchasan stated This is a case file. I don't even need to read that. Is there a serious issue to be tried? Mrs. Rose, for the respondent, submits that the failure of the claimant to comply with McIntosh J orders to pay cost and the starting of a similar claim against the same defendant based on the substantially the same facts constitute an abuse of process. There is a further contention that the issue before this court have already been litigated before McIntosh J. The court around them and I say, we'll not go with this again. We'll not go to the post. Andrew, them should have do something about this. This is a further contention that the issue before this court have already been litigated before McIntosh J and the respondent's application for eviction and the claimant's application for a stay of execution of the order against the occupants. That the actions of the claimants amounts to expropriation of the respondent's land in the high-handed manner, contrary to the orders of the court. The judiciary is anxious to preserve its capacity to intervene with unacceptable conduct is observed on the part of public bodies. It recognizing that public bodies remain subject to law. It recognizes that public bodies remain subject to law. How dare you break the law or break the court rule in the tab say people are going to riot? Mrs. Samuels Brown, QC, Queen's Counsel, that means, argues that the claim before McIntosh J was a claim couched in private law between private individuals, whereas the present claim is grounded in public law. The case for the occupants in, according to Mrs. Samuels Brown, sought to put up a defense of adverse possession, which was not found by the judge to be established. How can you hear that? And the idiot them around on the internet, oh, them depend it for how long, adverse possession, and I feel them land because them depend it how long, and man I come both say, oh, we depend the land from we are pitney. It is immaterial to what's happening. See here, Mrs. Brown QC argues that the claim before McIntosh J was a claim couched in private law between private individuals. And if I pronounce some of them something wrong, I don't know legal term. I just pronounce word because some of them word I when I see them in legal terms, they pronounce different. So forgive me. Whereas the present, me go on and write lawyers and a lawyer there. Whereas the present claim is grounded in public law. The case for the occupants in earlier claim, according to Mrs. Samuels Brown, sought to put up a defense of adverse possession which was not found by the judge to be established. No findings. An application for stay was made to facilitate an appeal, which was supported by an affidavit of Mr. Joseph Shokir. This did not make him a party to the litigation. The identification or public law issues are an insufficient answer to the defendant's argument that the issue have been ventilated before the courts. The issues have already been ventilated. Stop on the foolishness about no order never give for the people and come off of the man land. Let's figure out how we can help them. Stop be wrong and strong. Humble no self, brethren. The matter was already ventilated, and in the case when I read the earlier one the judge said, oh no fi build no more upon the man land, I want to pay the man 50,000, I want to demolish the house them on upon the man land. So when I come bad up people. How so wrong and strong? Come on, man. And then we insensitive, and we cruel, and we wicked, and we not see pitting out the door. You know, long the government could have moved on some no pitting off a ban over there. Yo, stop here, man. Me see the people that cause triple X. I tell triple X long time say, you know, PMP are done, you know. Me tell him, you know. I see them cause him now, because in contact truth. Tell you triple. That's why I never yet this year, you know. Because I know you're not done, boy. The principle remains intact that public authorities and public servants are, unless clearly exempted, answerable in the ordinary courts for wrongs done to individuals. So give me an next case file. C. Davy versus Spellthorne, Borough Council, and give me an next case file. Before J, listen this now, careful. Before McIntosh J, this is the previous judge, were rule. Excuse me. Before J, McIntosh J, none of the 99 defendants appeared. Not one of them go to court. Go plead them cause. Them are go done with me. Them are go hate me, God. God, them are go hate me. Jesus, them are go hate me. Jesus, why me? Why me, God? Why you never make somebody else see this? Why me, God? Them are hate me, God. But you're always there for me. Always there for me, God. Let me hate me a little more. What was there? The man said, take back the OD. You wicked. Take it back. Wicked. You not no heart. Jesus. Me the pan capture and court case go and I mean nothing. Me a show up. me address in our whole raggy daggily. Me a put a crocus bag on a court and me a ball to a judge. Me a carry pitting them too. Me a carry pitting them in a court. Me a said, judge, my mother, my grandmother did live there. Me put me high water now come go to and put a high water, dry water, run down. High water. Judge, we don't have nowhere to go judge. We don't know if we go judge. Bring them school, church. We don't have nowhere to go judge. We have beg a judge. Make a man give a little time. So we can relocate. Judge, do. PMP wicked. Come like PMP never even tell the people them to come. Not even get the people, our brothers and sisters, poor brothers and sisters, did not even get a chance to go plead them cause. This wicked PMP government should be not PMP government, PMP party. And that wicked PMP government are evil, heartless, wicked like PJ Patterson administration will take up the street people man carry down St. Elizabeth. It's the same PMP them. That's why Mark Golding can run down to the guy look like people them yay. After we no use them to win election. We not been using these people for win the seat. We not been using these people for win election for years. Wicked. Wicked. Not one of them showed up before Judge McIntosh. See that? I dare you not. Tell me, don't call me anything you want to come, but don't call me a liar. Trust me, my mother said word is win, but don't call me a liar. Before J. McIntosh, none of the 99 defendants appear. And 99 times 50,000 how much, Lashika? Lashika, 99 times 50,000 how much? 99 times 50,000 how much defendants appeared, but were represented by two officers of the Housing Agency of Jamaica, the HAJ, acting as duly authorized agents of the Ministry of Housing. Not even the minister showed up for the final. I accepted the submission of counsel for the respondent that the relief sought in both claims was the acquisition of the subject lands. In assertion to Mr. Shokir affidavit, in the earlier claim is as it is now that the Minister of Housing on February 29, 2012 orders declared that the respondent's land an improved area, because they want to call the land an improved area, you know, right? See the affidavit of Simone Morris Ratchery, dated May 18, 2012, supporting claim at paragraph 16, 8, and 19 in this claim. It is interesting to know that McIntosh J commented on the presence of the legal officers of HAJ as suggesting their involvement in the matter. The crucial suggestion is to determine whether a party is seeking to raise before the court an issue which could and should have been raised before. The court has to take a broad approach and determine whether in all circumstances a party's conduct is an abuse. And they tell about our next case file. The conduct of the parties was the subject of the strongest criticism from this court. See judgment on McIntosh J, where the learned judge described the application as iniquitous. Big word. Big word. We have to go look it up. We have to go look up. We have to go look. People, let's go. Iniquitous. Jesus. Big word. Where my boy say? Where say Marguerite with God with? Iniquitous. Iniquitous. I have to go look up this quick and fast. Big word.
Iniquitous.
Jesus. I pronounce it goodie. As a formal adjective that means grossly unfair, wicked, wicked, wicked PMP, wicked and morally wrong. Lord have mercy, God. Yo, black that's mad there. Come in, you know, how you come over like a JLP, the PMP, them tricky people, them. You have no sense. You have no sense. Hi, Marsha. Hi, Marsha. Jesus. I love listen to Marsha. I say Marsha. Scrub say, Marsha, Marsha, go over there, go tell her, say, why show the 20, show with 2025, Marsha, Marsha. Me say, Marsha, go over there. 25 ruling scrub say, Marsha, you know, say I receipt me thing there. Marsha, go over there. Go over, Marsha. You type that comment and she not answer. Marsha, go over there. Listen me, Marsha. Marsha, if you go over there to rat it. Marsha now get take up na the back, scrub get mad. Scrub said them know say I receipt me deal with. The woman I read since a 2025 court case. Scrub said, Marsha, go over there. Go over there, Marsha. Yeah, all right. All right, so Marsha, he said, the conduct of the parties was it, Marsha, have you gotten a chance to read this? To read this yet? We can't wait for you to read this. The conduct of the parties was the subject of the strongest criticism from this court. See judgment of McIntosh J, where the learned judge describes the application as iniquitous, wicked, iniquitous, and that it is devoid of sincerity. This is McIntosh, you know. Devoid. It lacks sincerity. The judge saw straight through the PMP and knows I use the people them. The judge saw straight through the PMP where I represent, said the claim said them I represent the people them. Not one of the people them show person them show a court. Not one. To go plead them cause. Is a wicked act them do to the people them. In this case, the procedure by which the ministerial declaration pursuant to the Housing Act was made, I find is irregular and is evidenced by procedural impropriety. The evidence before me offers no basis. Whatever you think the judge say, QC, I find is irregular and is evidence by procedural impropriety. The evidence before me offers no basis on which a ruling could be made by the minister pursuant to Section 4 of the Housing Act. What material did the minister consider in respect of the housing conditions in the area and the needs of the area with respect to further housing accommodation? This is very important, people. I told you earlier on. Them claims say they might use it on the Housing Act. They might use the Housing Act, right? But in order for them to use the Housing Act for take away the man land, they have to prove say there is housing conditions in the area which needs an area with respect to further housing accommodation. So they have to prove say the area needed more housing. That area is designed to develop tourism. I'm going to show you, if we have time, if my phone not dead for me, I'm going to show you how the government knew that this area and this thing when they carry go court, but how it is housing accommodation. That's why they might carry go court. So the people them can stay there. Yeah? I'm going to show you how the same government in 2012, I believe, the NHT, a merchant bank, and some company bought 9.5 or 9.3 acres of land in the same area for tourism development, not for housing. If I get time, I'll show you. The same government will come now and say them a housing accommodation they might do it for. It will seem that both the occupants and the defendants are determined to have any further housing accommodations of those land. The stated intent of Section 4 of the Housing Act expressly seeks to restrict further buildings. The injunctions sought by the claimants are geared to restrain any actions against current occupants currently occupying the lands. New Falmouth will therefore be free to restrict and hinder further housing accommodation being built. So here the judge say, it have to be either overcrowding, it have to be either we're not going to develop the land for people live, which none of the things sufficed. There was no overcrowding. The injunctions simply sought by the claimants are geared to restrain any actions against current occupants currently occupying the lands. New Falmouth will therefore be free. This is important. New Falmouth will therefore be free to restrict and hinder further housing accommodations being built. Section 4 has not been shown relevant to the circumstances existing on the land. Section 6 identifies for attention houses in disrepair or sanitary defects. The minister is required to be satisfied that in general the houses in that area are by reason of disrepair or sanitary defects unfit for human habitation, or by reason of their bad arrangement of the streets, or by reason of overcrowding in the area. So me tell you about overcrowding or lack of thereof, right? I think if the government said them need to develop the area, maybe the government have the rights. Don't hold me to that. But just work with what is here. They did not provide any evidence that there is overcrowding in the area, dangerous or injurious to the health of the inhabitants of the area, and that such condition can be effectively remedied without the demolition of all the buildings in the area. The affidavit of the Senior Management of Legal Service of HAJ, the duly authorized agent of the claimant, proves the contrary. The judge a boof them. The man then bring something to court and it proved the contrary. Miss Simone Morris Rattray at paragraph 14 states that nearly all the occupants have established permanent concrete structures on the land and have usual public amenities of water and electricity. So how did they carry to court? Yeah? How did they carry to court section 4? Section 4 states that it has to be reason of disrepair or sanitary defects unfit for human habitation, or by reason of their bad arrangement of the streets, or by reason of overcrowding in the area, dangerous or injurious to the health of habitants in the area. This is where the PMP can go court. And that such conditions can effectively remedied without the demolition of the buildings in the area. Their affidavit, the PMP affidavit of the senior manager for legal service, Ashia the lawyer, of HAJ, the duly authorized agent of the claimant, proves contrary, proved otherwise. Miss Simone Morris Rattray at paragraph 14 states that nearly all the occupants at the government has said this, you know. The government say all the occupants have established permanent concrete structures on the land and have the usual public amenities of water and electricity. The affidavit described the area as a vibrant community. In a fair affidavit, when they carry a court. And them go represent the people them. And here the clincher now. Let me give you the clincher now, Marsha. Let me give you the clincher. And I want to go over back a earlier section. That I maybe misspoke. Let me give you a clincher, ya Marsha. Oh no, say. After them try carry this now. Forget it back before the courts. When them rule against them. The last time it seems. You know what happened, people? And this is just my theory. Through the affidavit from the government say a bare concrete structure over there and them have amenities of water and electricity. Land. You know what them do? You know what them do, people? They start advising people, they start put up boardhouse over there. Over here look too good. Over here look too pretty. So you see part of the land where them nobody never capture yet. Somebody say over here too pretty. We cannot claim Section 4 of the Housing Act. We can't claim that. We can't claim Section 4 of the Housing Act. We need some old house over here, some pop down house and some unsanitary situation. Hence my speculation, Gillitangs. My theory, can maybe never hear, is that they start building board house them over there. It was a vibrant community, according to the affidavit. It was all concrete structures over there, some nice pretty house. So, I find that there is no evidence at the court, the judge, the QC. I find that there is no evidence before this court on the following. This is a clincher. That the minister has caused to be prepared proposal for a housing scheme as required by Section 4.2. Because what? None of this something where them say over there, no over there. No undeveloped this, no unsanitary thing, no house are broke down, none of that no over there. 2, that there is a prepared improvement scheme as required by Section 6.2 of the Housing Act. So not nobody if say them need to go fix up. Nobody said none of that. That the prepared improvement scheme has been approved by the minister as required by Section 11 of the Housing Act. So them not get no approval, them not get no plan, them have to lay out a plan and show said them are going to do this and this is what them are going to do within 9 months. None of that. There is no evidence to satisfy either the requisite state of the houses or the overcrowding or poor arrangement of the roads to suggest that the conditions that exist constitute a danger or is injurious to the health of the inhabitants. The evidence, as I have indicated, moves in other direction. That means that the people them living over there affluently, the people them on the manland have some nice pretty concrete house, the people them have proper road, water and electricity. Why the PMP, knowing this, did not work out something with Falmouth from then, before the man dead? Because family not take no talk now. Because the family not take no talk. The family up in them neck. Because they have them nice pretty hotel and no boardhouse and kind of sitting over there. And car wash and board this shop all kind of sitting and turn it in a slum. The people them not take no talk, people. They're not taking any talk. Last week and them not take no talk. Because when the place is nice and pretty so, it come like the owner before he dead didn't want to work out something with them, you know. But now, them bring in, everybody come live and create some different board infrastructure and something on the land. So the thing run down and people, yo, leave me alone, I'm not make nobody hate me. God, why you let me see this? Jesus. That the prepared, so the judge said, there is no evidence to satisfy either the requisite state of the houses or the overcrowding or poor arrangement of the roads. She said everything is moving, is in the other direction. Everything indicate moves in the other direction. Section 25 of the Housing Act provide that lands acquired. This is important because they say the government could have taken land and give people them. Section 25 of the Housing Act provide that lands acquired for the purposes of various acquisition schemes, and in relation to such acquisition, the purposes shall be deemed to be public purposes. This deeming provision raises a presumption that the purposes for the acquisition is for public purposes. This is a rebuttal presumption. The purpose of the 100 families in illegal occupation does not constitute a public purpose for the purpose of the Constitution of the Land Acquisition Act. That's what the judge ruled. What chap the line that talk about? What chap the line that talk about, Marsha? You see it here? It says Section 25 of the Housing Act provides that land acquired for the purposes of the various acquisition schemes, and in relation to such acquisition, the purposes shall deem to be public purposes. This deeming provision, raises a presumption. You're presuming that the purposes for the acquisition is for public purposes. This is a rebuttal presumption. The purpose of the 100 families in illegal occupation does not meet the threshold of public purpose. For the purpose of the Constitution and the Land Acquisition Act, it is permissible to look behind the stated purpose to reveal that it is a sham. The PMP go try tricky judge. I say, this have a public purpose. Like, oh, this have to benefit the public. How them people are, them need to live somewhere. Them people are suffer. Them people are living in a deplorable condition. Them people are no light. They are no water. Them live in a slum. It is permissible to look beyond the stated purpose to reveal that it's a sham. It's a sham. In this regard, I am mindful by my brother, the judge said, our brother, Macintosh J comments that the application is lacking in sincerity. Lacking in sincerity. Them a lie. Which public purposes? What? What about Tabo? Huh? All right. So let us define public purposes. Yeah? Or let's get a better understanding of public purposes. Yeah? Section 25. Yeah? Section 25 does not by itself say the minister can take any private land for housing. Rather, it connects compulsory acquisition to qualify a scheme approved under the Housing Act. So there are two important steps. There must be a qualifying scheme. Yeah? That means the land must be proposed to be acquired for the purposes that the scheme or something incidental connected to it. Only then does Section 25 say that the purposes is deemed to be a public purpose for the acquisition. The distinction became critical in this case. So here it goes. He said, how Section 4, 6, and 25 fit together. So he give a diagram. He said, think of them as a chain. Right? So I could go over this quickly. Section 4, when them go quote with, right? The minister identifies housing needs and declares a housing area. Yeah? So in order for them to declare it a housing area, they have to go through a process. Yeah? Before they can get it to be a housing scheme. So they say, yes, sir, yes, sir. This is going, yes, sir. People live a certain way, yes, sir. We can make them life better, blah, 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 blah. Then we are going to draw a plan and we are going to show them how we are going to develop the place and fix the place. So it can become a housing scheme. Right? So minister identifies needs to and declares a housing area. Housing scheme must be prepared. Section 6. If the problem is existing defective, overcrowded conditions that can be remedied without total demolition, the minister can establish an area, improvement area. So when they say them need to improve the area, the house them shikity, the water and them think about we can fix it up. So they might call us now an improvement area. So that's why them use Section 6. However, when the people them go there, and when the people them in them own affidavit, them say the people them live like affluent people. So how did the government use Section 6 of the Housing Act? And the people them in them see one in the affidavit that say the people them have running water, light, and proper building. So then you go to improvement scheme must be prepared. Yeah? So Section 11, where them draft to, the scheme must be approved. Where them have to go through the different channels them, right? So land required for the for the approved scheme can be acquired under the Land Acquisition Act. The Act deems the acquisition purpose to be public purpose. Here we get the public purpose now. Yeah? So the land required for approval scheme can be acquired under the Land Acquisition Act. But all of the things we name out first, right? Like we have to say, you approved, it have to be approved, it have to be designated as a housing area, it have to be designated as a housing scheme, it have to be designated as an improved area. Then before you can get to what? It's for public purpose. So the court essentially asks, can the government rely on Section 25 to compulsory acquire the private land if the statutory scheme requirements haven't actually been satisfied? The court's findings were significant. At paragraph 31, Justice Campbell identified the absence of evidence concerning the proposal required by Section 4.2, the improvement scheme required by Section 6.2, approval of the improvement scheme under Section 11, and paragraph 32, the court explained that Section 25, the one about public purposes, Section 25 declared that the purpose are deemed to be public purposes create a rebuttal presumption. It does not necessarily make every acquisition automatically lawful or immune from challenge. Wanna get it? Everybody get it? All right. So in a nutshell, it has a basically the people them claim so they go fight for the people them get the land. Then go to the court, them say, them people here live on the land for how long? Right? So we need to create a housing scheme. Right? They need to create a housing scheme. Right? Problem is they don't carry no proper documentation to prove such. The improvement area, no. Housing area, no. Housing scheme, no. Can you take a private land and just sit on the private land and just tell lie and make up things to say you are going to just use this for public purposes? No. If the law was to allow you to just come take my land and say, oh, the people who live on it, we build up a concrete structure on it and I live proper. If you come say them and suffer in the court, not see no evidence of them suffering or whatever, or deplorable condition or them sitting there where you say I go develop and whatever, the court now go buy it. I get a charger. So me not understand how chop the line thinking can do a better job. What is what's gonna be chop the line argument? Eh? Same thing happened with St. Thomas. Can be a concrete structure and be a good living, me say them a go with and them a bother people. Eh? How chop the line? What argument chop the line is gonna use? Alright. So you give me an next case file. I don't think we need that. So we'll read this again. Land Acquisition Act, it is permissible to look behind the stated purpose to reveal that it's a sham. Those are strong words from the judge, you know. The judge has said the PNP is a sham. People are lying not to you. Don't make the PNP them read nothing and trick, you know. See it here? The purpose of 100 families in illegal occupation does not constitute a public purpose. For the purpose of the Constitution and the Land Acquisition Act, we chop the line when one go use. It is permissible to look behind the stated purposes to reveal that it's a sham. I lie not to you. See that? This is judge number 3. Permissible to look behind the stated purpose to reveal it's a sham. In this regard, I am mindful of my brother McIntosh comments that the application is lacking in sincerity. In other words, the judge said the PNP are lied. What can chop the line do? Continue tapping up people because we are come to the end of it. All right, so this is a case file, case file, case file. Oh, this is a good read. In Bethel and others appellants versus Attorney General of the Commonwealth of Bahamas. It was held, it is cleared on the one hand, and there may be cases in which it is open to an owner to show that the purposes behind the acquisition is not genuine. A striking example was Toussaint versus Attorney General of St. Vincent and the Grenadines, 2007, in which it was alleged that the true reason for the acquisition were political and that the stated purpose of having a learning resource center was a sham. There was no dispute that this was a proper subject of investigation by the courts. The main issue being whether it were permissible to look at a statement by the Prime Minister to the House of Assembly to determine that issue. And again, another case file. Yeah? And the argument of the appellants really rested upon the view that there cannot be a public purpose in taking land if the land went, whoa, this is very good. This is very good. The argument of the appellants is really rested upon the view that there cannot be a public purpose. So we go to public purpose again. In taking land if the land when taken is not in some way or the other made available to the public at large. The man never make him land available to the public at large. So the PMP card this got quote, public purpose, this. What is this? See, it's here. It's an argument of the appellants is really rested upon the view that there cannot be a public purpose in taking land if that land, when it's taken, is not in some way or the other made available to the public at large. The Lordship do not agree with this view. They think the true view is well expressed by Bachelor J in the first case when he says general definitions are, I think, rather to be avoided where the avoidance is possible. And I make no attempt to define precisely the extent of the phrase public purposes. He said, I make no attempt to define precisely, the extent of the phrase public purpose in the least. It is not enough to say that, in my opinion, the phrase whatever else it may mean must include a purpose. That is, an object or aim in which the general interest of the community, as opposed to the particular interest of individuals, is directly and vitally concerned. Chief Justice Byron, who wrote the judgment with which the other members concurred, agreed, distinguished the United States Supreme Court decision of Missouri, on which the appellant before him relied on demonstrative violation of the Constitution brought about by the compulsory taking of private benefit of individuals as opposed to the public purpose for the general interest of the community. In Missouri PAC RL case, the petitioners did not succeed because the Supreme Court found, in other words of Grade J, the petitioners How do I do this? Come on. Come now, something. Stop, no man. I'm not trying to highlight you. Calm down. What the hell? Off. Good. The petitioners were merely private individuals, voluntarily associated together for their own benefit. They do not appear to have been incorporated by the state for any public purpose whatever, or to have themselves intended to establish. And anybody will understand how law business go and court business go, they have to use case file to make them decisions. So when they basically I say, yo, that has never worked anywhere. We can take people private land and say a public purpose with people living on it. living a certain lifestyle or a certain affluent lifestyle based on this situation in Jamaica. Good. Chief Justice Byron will read the next case file. The next case file. So this is the judge again. You know, some good something this. No, we can't read all right, people. Some good something this. These are very, very good points. All right. I find that the squatters, whom the claimant represents, are merely private individuals voluntarily associated for their own benefit. Jesus Christ. Mighty boy. Oh my gosh. It's like a judge just gave them one backhand slap. Like a judge just give PMP one backhand slap. Listen. And me call them, the man that was nobody can call them squatters in Jamaica. And me call no subject to people. Do not curse me out. And me say when a squatter. I find that the squatters, whom the claimants represents, are merely private individuals voluntarily associated with their own benefit. The benefit being to acquire an interest in the respondent's land. The association is devoid of any public purpose. It's the ruling that the minister's declaration is not compliant with the order of the Supreme Court as contained in the judgment of McIntosh J. It is admitted purpose is to prevent dispossession of the families in occupation consequent on the order of McIntosh J, and to prevent the serious social and economic upheaval which Mr. Shokir perceives will follow the implementation of the order. Here, this judge is repeating the nonsense where the PMP bring to my court. Say there's gonna be social and economic upheaval. There can be no public purpose or furtherance of the general interest of the community as opposed to the particular interest of the individuals, requiring the respondent to locate these families on its land in flagrant breach of the orders of this court. There is no public purpose benefiting compelling the respondent against its will to transfer an estate in part of the land which it owns and hold as its private property to voluntarily association of private individuals for the purpose of erecting and maintaining their houses and buildings there and for their own benefit. For the reasons outlined, the claimant has not satisfied this court, and there are serious issues or any issues of all to be tried in this matter. Mighty God. Don't make PMP fool no people. I use the PMP, use the people them. Not one out of the persons them show up a court to defend them standings. How them standing? To plead them cause to the judge them. The PMP showed up and actually misrepresented them. Promise them, say them are going to give them land. All up to what the mayor said, them go campaign down, they say them are going to give them it. Nonetheless, in the event, so you're the judge, nonetheless, in the event I am wrong, I turn my attention to the balance of convenience. The purpose of interlocutory injunction is to improve the chance of the court to do justice after the termination of the merits at trial. At the interlocutory stage, the court must therefore assess whether granting or withholding is more likely to produce a just result. Should the injunction be granted? The respondent will experience an expansion in the buildings of the number of illegal occupants on the lands. Jesus Christ, the judge beat them. The judge just have beat up the PNP, them and kick them all over the place. Or abal them. The judge say, well, no one go before court, we go file, we go trial. He go just what? Expand the buildings of number of illegal occupants on the people them land. The community will be aware that the efforts made by the respondents to evict the occupants from the land, although successful before the Supreme Court, has been resisted by the occupants, who have succeeded in obtaining from the same court a restraint on the respondent from evicting them. The respondent's effort to secure its borders from new interlopers whilst being restrained from interfering with the current occupants currently occupying the land will therefore be more difficult. The cost of consumption of the utilities such as electricity and water will be for the account of the respondent. Jesus Christ have mercy. Me know that this will come up. This happened to me. This happened to me, people. This happened to me. The man left a light bill and me have to pay for it. People who have no land and live a foreign, go check for no land. Go check for no land. Go check for no land. Because people live on land things and they own it because they did it for 10 years or 12 years. Go check for no land. The judge said the respondent's effort to secure its borders from new interlopers whilst being restrained from interfering with the current occupants currently occupying the land will therefore be more difficult. The cost of consumption of utilities such as electricity and water will be for the account of the respondent. In the event of non-payment by illegal occupants on his land, or whom he has no control, the PNP wanted to drag out the case for go trial, and the judge said no. Me not grant to know that the illegal occupants are going to left a bill give the man, which may be the case right now. Plus the man 50,000 from 2012 per occupants. You know how much that now? The man might sue the government because the government breached. Chop the line a idiot, a kwashi. People chop the line a dunce. And me no bright. As Scrubber said, me no bright, you know. Me no bright. Me no bright, you know. Jesus crumbsums. Now this I want calculator, me no bright. Eh? $4,950,000 was to be collected in 2012. From 2012 to 2026. Check that interest. The people for the land can sue the government. Forget the money where the court ordered. You know why they can sue the government? Because the government went behind the court's back and gazetted something and give the people them a stay. The PNP went behind the government, the ruling, and go tell the people them, say they have stay. And the judge reprimanded them. So this $500,000 where the man did forget. Can you imagine the interest now upon that? The man have want the money and pick them. So it's a read the script. Should the claimant's application fail and they succeed in substantive matter, there is the threat of eviction from the respondent's land and eventual demolition of their buildings. The occupants have, however, remained undaunted by that threat. No, let me read earlier on. Sorry. The inability or unwillingness of the occupants to comply with the court orders for damages and costs in the earlier matter. Now, this is important. I'm glad to read it back. This is very important, people. So, me just talk about it. The inability or unwillingness of the occupants to comply with the orders for the damages and costs in the earlier matter, and the absence of the usual undertaking for damages by the client, places the respondent at a disadvantage should the claimant's application fail and they succeed on the substantive matter. There is the threat of eviction from the respondent's land and the eventual demolition of their buildings. The judge saw it coming. The judge said, me nah make this matter drag out any longer because people are going to continue to build. Them are going to build up more infrastructure upon the land and there will be a demolition when the people them... Jesus pieces. The occupants have, however, remained undaunted by the threat. Jesus Christ. No, that's when we realize now the man them out there about themselves. So I said them can't be no squatters because them are Jamaican. Yes, Papa Jesus, come here. Michael Manley Ghost is awake. Here, them we still have socialism in Jamaica. A Cuba. Me work hard and you just come take my things. And me have to share it equally with you. Me moving out. Me moving out. Me moving out, people. Me not invest nothing more. And all investors should have started pack them back. If at this way I go to. Eh? The occupants this is from what? What are the people, man? What are the man? You know, so I not highlight this something. I know I'm gonna need it to know. What are the people? What are they? This is 2013, February 2014. So these are the last situation, right? It says the occupants have, however, remained undaunted, unbothered. They are unbothered. They don't care. We're sovereign. We ancestors bleed for this. The rich people can't come own the land of Jamaica. The uptown white boy can't come own the land down here. And the foreigner can't come buy the land of our own. Leave me out of politics. You know what? Let me love politics here. Not politics that agree. The occupants, however, remained undaunted by the threat since McIntosh J. order. The claimant has alleged that there are likely to be social and economic upheaval. The balance of convenience lies in favor of refusing the application. Application refused. The claimant's conduct. This disposes of the claimant's application. Nonetheless, I will be minded to refuse the application based solely on the conduct of the claimant. This is the judge I reprimand him again. The claimant must come to equity with clean hands. People, if you think I make up this to backside, none can go so people. None can go so. No follow don't say PMP we can't show no where they read people. No follow them people. No follow them. Follow me. Follow me, people. Claimant's conduct. Look at this. Look at the judge above them. And this chap the line one go take up. That disposes of the claimant's application nonetheless. I will be minded to refuse the application based solely, entirely, on the conduct of the claimant. The claimant must come to equity with clean hands. See that? The PMP got there, I try trick the judge and I use the people them. He said, see Malone versus Metropolitan Police Commission, they get an next case file, the judge kill them a case file. The claimant conduct in this matter has been less than fair. God, people, good Jesus. Where I was scrub there. Master, you have to go read this scrub. Macintosh J judgment was delivered on New Falmouth claim, which had been filed in 2007. The court ordered, Jesus Christ, it's Tova Hamilton. Let me tell you something, Tova Hamilton. I wish somebody can make you go read the case file. Because you came out and you spoke irresponsibly. You come out, come talk about say, you don't know of no eviction notice and something there. You don't need to stop freestyling as representatives for the people, as government officials, you have to put forward information to the public. Cogent information, like George Davis, that can be verified. As Cliff Hughes used to say, verified. But we're not going to beat you up, because we know their constituents them. But listen to Tova, PMP trick them. Tova, PMP trick them. See it ya? The claimant's conduct in this matter, this is the government, being less than fair to who? The man who own the land. The people them who own the land. So when I cost the judge now too, like when I cost me, and triplex. On the 6th of April 2012, Macintosh J judgment was delivered on New Falmouth claim, which had been filed in 2007. The court ordered the occupants to give up possession and pay damages and cost since 2012. Big up for y'all who stay for the movie end. That's how people drop a sleep. The movie long. But we had to read the whole thing. See that? I ain't making up nothing. See that? Boldly in red. Impact, see that? Do not like PMP fool, you know. Chop the line a criminal sympathizer, it seems. Chop the line a past criminal so he might look people when can relate to. Chop the line and look people when can relate to him while everybody have a police record. Is a criminal mindset of a politician. Is a criminal mindset of people who believe that when people have them things that feed them own. And they want to get rid of crime and violence when you have people who are ready and bad mind and think that you feel where you work out for your things that you can kill your feet. And what kind of society we are trying to build? What do you mean say the judge never passed no judgment? What do you mean the court never give no order? What do you mean? Look how much years the court are telling people this. Blame your mother and your grandmother and your grandfather and your father whosoever did build up sitting upon the people in place and continue to build. You think everybody at Jamaica going to be just this lawless set of people? No, somehow we are going to take the buffing, but we are going to continue to be lawful. We, the people of Jamaica, we now make on run we out. We're not crazy. And then you come back and say we not have no sympathy, and we have sympathy for the children them. But everybody will come out come say something constructive. We not go after them. What do you mean? What not talk about? A board house me grew up in. My mother never go take nobody land. Me never buy no gold spoon in my mouth like Santa Claus them. Me never ban no gold spoon in my mouth like Jordan them. My mother used to cook dashing for Kalaloo. And true cow skin was the cheapest thing when you have that every Sunday. The amount of cow skin in my back to rot in. Me thought get pit with me at 33 and a 7 me gone. A big cow skin in my back. Bright. My mother she walk and wash people clothes. The things that she interested go take on the people and we left big yard. 59 Manizil Road. Remember we in the truck back. Me about 3-year-old in the truck back and we drive a truck a rookie to go and the whole truck. And go a Pigeon Valley go live. Without no father. I want to know. I want to know. And I one time I see my mother find one little man. Near Masken. One time, out of all of that, I see my mother find a man. She walk and take care of it. One woman, I want to know man, mother and father that. She buy her 2 little goat and people go and kill all the goat them and thief the goat them and she buy back 2 little goat again. Ask anybody where come from Pigeon Valley. Ask anybody where come from Pigeon Valley about me. How me and my little brother, how my mother walk and wash people clothes so we eat. You think so we grow no gold spoon in our mouth? You think so we have TV in our house and a light? You think so no boy we did have good life and run and sell cocaine? Run and smuggle cocaine cross border can give you no chat? When your father a big singer you gonna smuggle drugs? Eh? And I come tell people about if chap line. Big old workless man. Your father a big superstar you gonna carry coke. And through Jamaican people fool them vote in and get rid of Anne-Marie Vaz and come go and like say you have no authority boy, you have to come lecture we. Come talk about say people for broke off things and carry show say them they made have house and chap line. Who you? Who you? Who you? When next I go tell the people them say them to carry drugs? Who are you? Who are you? Which Jamaica? You idiot, man. Not that Jamaica where Andrew Wallace them fix up and put police everywhere. A camera everywhere to catch criminal. Not that Jamaica, yeah. Nah idiot, man. Nah idiot. So the court ordered occupants to give up possession and pay damages and cost. All of a sudden, no one hear nothing from court and a court and a run got to forget when no one win case. At the same Supreme Court and a run go to one the Privy Council and a run go to one and no one win case. I want to want take free gunman. When no want free criminals. When a run go to Supreme Court and run go to Privy Council. And run go to appeal courts. But now the court rule and I go about say when I talk like so when I rate the court again, you know why I hear nothing from the court again. The court said they were ordered to give up occupants and pay $50,000 each. We're not going to take a whole out for idiot. There is no appeal of this decision. See it here. So we don't know a big old idiot, drug smuggling idiot they talk about say him a fool you go for fool the people and playing at the people in emotion. I go for score political points about the people in turmoil. I go for score political points about the people in situation where they go through. Yeah, the white man. See, the court say, there was no appeal of this decision. Nobody can appeal that the man get the final thing for people that come off him land. How did we get it? How did we get to this? How did we get to this? And because the people afraid, say they're gonna be upheaval, there's gonna be conflict. The people afraid because the PMP tell them say they're gonna be social turmoil, and that the PMP put in the affidavit. So why everyone the people in the go around by them said them are going to carry police because the PMP say they're going to be social turmoil. And that the PMP put in the affidavit. So the people them have all the right to carry police with them and show up any time of morning when them know say people are asleep because they were afraid of what the PMP said would happen. And PMP said they're going to be social and economic turmoil, and that is it. Threats for the man land. How dare you? And then you come and say we artists and we wicked. So he said there was no appeal of this decision. Yeah? No appeal. The PMP walk left it. The PMP walk left the decision and left the people in it. After they go tell the judge say, then go over there and say be a pretty building. The people might live rich, judge. They might live rich. They have water and electricity. They might live good. And them go tell the judge that. On the 16th of April 2012, the claimant caused a valuation to be done of the respondent's property by a firm of valuators. The report stated 28th of April 2011 was completed by a firm, Alice Peter and Company. There was no explanation under what authority such a valuation was done. Aye. Lord, if you're not busy, come here. The PMP Marsha go value the man land and I'll know they can show where the authority come from. This is document that need one proper broke it down. That document that needs somebody way brighter than me if you go through it. That I cannot for the life of me understand why the Jamaica Labour Party always make the PMP come out come boof boofing up so. Me cannot understand the Jamaica Labour Party lawyers them. Me can't understand the Jamaica Labour Party scholars them. Or just always have wheel little ticky we just go to school one day. We just get degree one day. If they come out and do their work here. So they can't tell MunchieB session officer them something there. Where are the lawyers for the Jamaica Labour Party? We have to depend on Jamaica 411 to get a little proper something them. And she's not going to go through it, all of this like how me do it, have to go do it in 5 parts. We need the PM and the people in charge of the Jamaica Labour Party to make the lawyer them where I represent the Jamaica Labour Party start do them job. Stop make PMP go on and tell lies. Keep forums, keep town hall meetings, go on press conferences, bring lawyers with UNO to broke it down. The PMP trick the people them. The court ordered the occupants to give up possession and pay damages. And from 2012, the court telling them to come off our people in land. Y'all continue to build. Now we are look for the people and for do the people and not about people for bond down and people not for support the people. What are you talking about? What are you talking about? Yo, me not turn a politician because me go tell the truth and you not gonna like me. Plus you get an extra 14 years. After the order, you get 14 more years. Right now, when the people come and bulldoze on place and buck down place, you should laugh and say 14 more years we get, plus the 12 where we get, and plus the 30 where we get. You know how much money we save up right now? Right now, we are moving our new house because we never pay a rent yet. We never pay a mortgage yet. We never pay a light bill yet. We never pay a water bill yet. The amount of money we save. Everybody are poor people them there. All the PMP said, I'll be a pretty house over there. All the PMP said there was no deplorable conditions over there. So we are talking about poor people. The PMP and them affidavit. Say the house them and the man and the owner for the property. Say the house them were proper housing. The PMP couldn't even use the housing act the way the houses were properly built. So we're not talking about poor people. The poor people, them come after. When them try to put board over there, because them want to claim the Housing Act, subsection, section 4. Then go make the people them talk put up board house over the people in place. Nobody now trick me or fool me. There was no appeal on this decision. On the 16th of April 2012, the claimant caused a valuation to be done of the respondent's property by a firm valuators. The report dated the 20th of April 2011. Was completed by a firm, Alice Peter and Company. There is no explanation under what authority such a valuation was done. The Housing Act does not authorize any such valuation of the respondent's land. So them no go value people land. I must say them a walk around and say man land worth 15 million. So if the man land worth 50 million, how comes the housing trust and the merchant bank lend people money to buy a similar piece of land for 311 million? Go look it up. How comes the NHT and the merchant bank lend people money and the NHT stand as guarantor? Eh? How no I run on that about the man land was 15 million when the NHT buys piece similar, make man buy piece similar, I don't know where they stand guarantee for 311 or 312 million. In the same community, the same area. Who not try fool? There is no explanation under what authority evaluation was done. The Housing Act does not authorize any valuation of the respondent land. So on the value the man land. There is no evidence that the declaration that the subject's land is required for a public purpose and that such declaration has been published in the Gazette in accordance with the Lands Acquisition Act. The court of the 20th of April 2012 heard the occupant's application for injunctive relief and stay of execution, which was refused by Judge McIntosh. On the 4th day of May 2012, the court ruled the application iniquitous, again Marsha, wicked, and devoid of sincerity. The written judgment noted the present in chambers of legal officers of the housing agency, and a copy of the orders were handed to these officers. The court had before it, as this court has, the minister's intention to acquire the lands and all the facts that are presently before me. On the 15th of May 2012, the minister's declaration constituting the subject lands as improvement area was gazetted. In affidavit dated the 18th of May 2012, Simone Morris Rattray, as authorized agent of the claimant, indicated that the claimant has an interest in the matter as it touches and concern the occupation of land of which significant community of persons have been in possession. Paragraph 23 explained that the strict compliance with the court order will cause social turmoil. That's in the government affidavit. So when I ask why police go around there, what are you all saying? The PMP tell them so. Say that cause social unrest. The affidavit proceeds to explain that the appellants are seeking to regularize their occupation of the respondent's land through a scheme of arrangements with the Minister and Commissioner of Lands at the Housing Agency of Jamaica Limited, Mr. Shochair's affidavit of the 7th of June 2012. That the Minister's objectives are complementary to the national policy of housing and development, especially as it relates to provide security of tenure to the working poor. The Housing Act and the Land Acquisition Act do not provide for the compulsory acquisition of privately owned land in order to transfer an interest to a community of persons who have occupied those land despite efforts of the owner to evict and in defiance to orders of the Supreme Court. The Housing Act, where chap the line we're going to use, do not provide for compulsory acquisition of privately owned land in order to transfer an interest to a community of persons who have occupied those lands despite effort of the owner to evict and in defiance of orders of the Supreme Court. You can't go against the Supreme Court and stop the man from evict people. And the court said that. I'm not sure the people them. People are saying the people them wicked enough. People are saying people them wicked enough. And then go to 3 o'clock go do all of this, But people have to look on causality. effect to one population. The people then go on and say, bro, you know, say when Tova go there and beg the people them say, yo, give it 2 weeks. You know, say people man allow them to put up the tent. The same people them, what they are burn out and I say, oh, them evil and one bag of something, really, blah, blah, yeah. But make us look at the side of the people that say, you know what? Now go on 2 more weeks. Put up a tent them. People then could have said, we don't want a tent fire. Government take them, can they go somewhere? Because what? The people them according to the court document, it says here, the people them defied the court orders. And in defiance of the Supreme Court, I share the view of my brother Mackintosh that the application of the claimant is insincere and iniquitous. She repeated what the judge before her, Mr. Mackintosh, said. Said insincere and wicked. The Constitution protects private property and does not provide. Listen now. Here, Chaplain at about Constitution. The Constitution protects private property and does not provide cover for the acquisition of private property in order to regularize the unlawful occupation of squatters. Hard-working people, they have nothing to worry about. This big old idiot boy, this old drug mule, we are come tell you about Supreme Court, the Supreme Court that is a damn idiot. The Constitution protects private property and does not provide cover for the acquisition of private property in order to regularize the unlawful occupation of squatters. And I call them so. See it there. So you can beat me all in one. See it there. See it there. Big in a red. Big in a red. See there. The Constitution protects private property and does not provide covers for the acquisition of private property in order to regularize the unlawful occupations of squatters. Missing man out of St. Thomas about say, by force them are going to take it. Then when we have the military and the police for, and you don't send a threat already, when them are come for kick on off them for bring the, I see when them are bring the police, them are come early morning when they're not asleep too. And so you say you're going to take it by force, yeah, them are going to detain you. Because we don't want nobody get hurt. So we are going to detain them because we don't want nobody get hurt. Because somebody go to live for some police shoot him and a problem. We don't want a problem. So all who want about say judge, police take man and can go detain is the PMP tell them say they're gonna be social turmoil. So they were taking precautions. They were avoiding anyone from getting hurt. I have not been shown any authority that imposes an obligation on a private landowner to make available his land to a community of persons in unlawful occupation in order to prevent those persons bringing on social unrest. Do not ask me why the police them went there. Ask the PMP. This is the judge speaking. I have not been shown any authority that imposes an obligation on a private landowner to make available his land to a community of persons unlawful occupation in order to prevent those persons from bringing on social unrest. The PMP are trying to play tricks, mind game, and at the same time, I make people look like them a criminal. So the judge supposed to perceive them as being criminals. You take up people and now cause social unrest. Are you crazy? The Constitution does not reserve the right to ownership of large tracts of land to persons of any particular social class, color, or creed. Macintosh, see that? So when I come to about say people of own land and Jamaica and own land, see that the Constitution does not reserve the right to ownership of large tracts of land to persons of any particular social class, color, or creed. So all poor people can own peace. No for one mama couldn't read or write and she left sitting go no. My mama walk and wash people clothes and she buy one house. She save up a little money buy one house. And when I turn artist, I go fix it up and she sell it and she get one bag of money off it. And I walk, she used to walk and wash people clothes. And before me bust, she buy her house. There are people with ambition. Don't tell me no bullshit. And stop watch people who work hard for them things. Stop watch rich people, because rich people have to work too. The Constitution does not reserve the right to ownership of large tracts of land to persons of any particular social class, color, or creed. Macintosh J has driven to describe the earlier application on behalf of the occupants as insincere and iniquitous, wicked. No doubt because of the total disregard for the defendant's fundamental rights. See the people, how dare you not, I hit today I talk about. The defendant's fundamental rights. And them still make you can put up tent over there. Uno, listen me no man, listen me. Uno not go hate me no. Uno not go hate me, uno not go hate the truth. What about the rights of the defendants? The court has formed the view that the hardship that has been visited on the defendants appear to be a consequence of a view on which public officials and claimants seemed to have acted. That Mr. Chisholm, not being from a line of traditional large landowners, has no right to ownership of such a relatively large tract of land. That's why me hear why idiot today asks about say, oh man, we own 300 acre of land and them this and them a come from area we own 300 acre land. The Constitution tell us he can't own it. Him legally own it. That is what the PMP are trying to tell them. This is what Chop the Line are trying to tell them. But this court, the Supreme Court, has formed the view that the hardship that has been visited on the defendant appears to be a consequence of a view on which public officials, which is the government, and the claimant seem to have acted that Mr. Chisholm, the man who owned the property, not being from a line of traditional large landowners, has no right to ownership of such large, relatively tracts of land. Relatively large tracts of land. If I am correct in that view, the remedy to that malady is an emancipation of those minds of enslaved. The claimants so let me get boofy again. The claimant's application is dismissed. Which up the line I go? The defendant's application to strike out the claimant is granted. There you go. Big up all who stay to the conclusion. See it there. See it there. See it there, Scrubs. See it there. You like evidence. See it there. Don't make water out them trick you. Cost, listen. Cost to the defendant to be assessed. Yeah? On an indemnity basis. Marsha, big word. Indemnity. Well, Marsha, there. Indemnity. Indemnity is a promise by one party to pay for the losses or damages of another party. I sorry say I'm my government in a power, but I can't say it. Yeah, the PMP acted viciously on this man, wickedly on this man, and the man and his family and everything that they're going through today with wicked PMP a show up on the site after them do all of this. They should sue them. Indemnity is a promise by one party to pay for the losses or damages of another party. It acts as a safety shield or a transfer of risk. If bad things happen, the person with the indemnity does not have to pay. But if Andrew now if the government should be sued now and the people are compensated, you're going to hear say Andrew friend them. You're going to hear say Andrew friend them so they can put in picture in a bulldoze land and put Mark Gold in a put up stop sign. This is the Jamaica we live in with wicked, evil PMP supporters. Not knowing that you can go and read up the case file and see how wicked the PMP was to these people or is to these people. Eh? But Andrew in a bulldozer. Look at you. Say, cost to the defendant to be assessed on an indemnity basis, the cost order in this claim and the cost of damages awarded by, the people get a second, Marsha, the people, the 50,000, the first Judge McIntosh said them for pay now. This judge said only for pay the man damages. That you know what damages mean? The fact that the PMP are thing there. We call it now. We call it man. We call it man. One call it man being prejudiced against the man, and that me I look for. Me I use that in the time being, right? I treat the man like him not supposed to own so much land. The judge ruled say only for pay the man damages. Right? So it's a cost to the defendant to be assessed on an indemnity basis, the cost order in this claim and to the cost of the damages awarded by McIntosh J be paid before any further step is taken in this matter. And there goes the conclusion. That is the final. Thank you for staying true. We've been here for so long. Jesus Christ, how much hour we gone? I'm going to go download the whole of this and put it on my YouTube. Because this official. We are the PM, we're the PM legal team. The PM's legal team. We are the JLP legal team. The JLP's legal team. Stop, stay silent on matters where the public's supposed to know about. Go out there and prove to the people how wicked the PMP deal with the people them and leave them in this situation. And you want a one term, second term now, MP, to fix the wickedness we want to do. To fix the evil we want to do to the people them. We have chopped the line and now the box and we jump up and a hallelujah. And hey, you really gonna go down there? Again, people, case file, the Minister of Housing versus New Falmouth Resort. Okay? And there you have it. There you have it. The evil PMP used the people for how many years for a win election and did not even appeal it. They did not even appeal McIntosh ruling. Then go with one little sitting board, them want to go trial. And the judge run them. The judge run them and say, "Uno dishonest, uno insincere, and uno wicked." And uno fe pay the man, compensate the man for damages, because uno stereotype the man, uno profile the man. And now his children are acting and uno don't like the bitter medicine uno get. Curse the PMP. Stop run round and make PMP vloggers them fool uno. And them surrogates them. And civil group them. And gleaner. Stop let them fool you. This is just one of the cases with the PMP. One of the many wickedness of the PMP. I see him so then treat Westmoreland until the hurricane come, we see everything. But Andrew fix it in a one night. Big word impact. Them iniquitous. Big word. Let us remember that word. The PMP is iniquitous. Is an iniquitous party. Big word. Remember it. Just remember iniquity and you remember it. Just remember iniquity. As some remember words. Iniquity. And you remember say them iniquitous. Good? So, there goes the truth of the matter. There goes the truth of the matter. It has nothing to do with no labor right. Nothing to do with no Andrew wholeness. It has to do 100% with the wicked PMP party. When none of them never make care one of the people them were squat. Not one of the squatters them go a court. Because they believe them could have take away private people land and these people to vote for them. They thought they could have take away the man land, Mr. Chisholm land, and ghetto people for win election. And that's why Mark Golding gone down there now and look votes. But people of Trelawney, do not be fooled. Because if them do it to these people, what will they do to you? People of Portland, who elected an MP and replaced Anne-Marie Vaz. And in the all over place like one common cock. I look another cock for fight. He run Ghana and Trelawney and forget say he have work to do over Portland. A Trelawney elected him? Is he the opposite? A Trelawney elect him? Eh? But him want to come teach Pitney and teach Jamaicans to chop lion. Eh? Once a criminal, always a criminal. Have a good night.